Namaskar and welcome to Chat with Rohan, in conversation with a living legal legend, a giant amongst men, and one of my idols, Justice Venkatachaliah. A man in whose honor Mr. Fali Nariman once said that wherever Napoleon stood in the middle of the battlefield was the center of the battlefield, and whenever or wherever Justice Venkatachaliah sat in the Supreme Court was the center of the Supreme Court. It's an honor and a privilege to be here with you this morning, Justice Venkatachaliah. Pranam.
Thank you so much for your kindness.
Sir, if one were to retrace your journey to perhaps the time you were a student studying to be a lawyer, your father was a lawyer, he was the founder principal of Government Law College, Bangalore. Your maternal grandfather was a judge. In fact, he instilled in you a spirit of reading and learning the Hindu editorial, for which your reward was an anna and the stick was a tap on the head if you got the pronunciation and intonation correct. So were the seeds of intellect and the pursuit of knowledge sown very early on in life?
Those were very gracious days and leisurely times. Society didn't have to face the kind of challenges that it has to face today. We have if I may say so, a civilizational burden that we want to compete with everybody else for standards of living, not particularly quality of life. And this perhaps a minimum standard of living for everyone is what we bargained for. That was the social contract. Why do we men associate themselves into a society? Why do they sacrifice their personal liberty and agree to bind themselves by a social contract? Long time ago, a Greek philosopher answered this: because a man is incomplete by himself. He needs the companionship of his fellow men to the completion of his own personality. And we joined together into a political and social organization with a view to providing the highest opportunity to everyone, each one, of achieving his best self. This is the social contract. Gandhi asked the same question. If society fails to provide this minimum assurance of the social contract, why should it obey the laws of the society and the community? This is an ever-recurring theme in civilizational debate.
Speaking of rethinking the social contract, in your address from 1991 to the Bangalore Advocates Endowment Association, you spoke about law and protection from power. You spoke about the consequences of big government and the consequences of nonfeasance versus malfeasance. Would you like to share a little something with our viewers about your rethinking of the social contract?
Thank you very much for this beautiful question. Essentially, the question of the responsibility of the state towards the citizen. The sovereign power, as we have enthroned authority over fellow men of a few who control the instruments of power. Any government, for that matter, is a huge giant of a machine which runs by greed and need. And in the process of what is called administration, human dignity sometimes becomes the victim. That's why for 5 centuries we have seen this kind of authority of, in fact it was said, it was the original superstition that superstition, the divine right of kings. That superstition became the superstition of the divine right of Parliament. There's a beautiful case called the Habeas Corpus Reforms Act of 1679. Nobody was challenging the state's authority to detain a person without trial for suspected anti-national activities. But everybody was concerned with the administration, the state's reluctance to subject that exercise that power to judicial review. Nobody said, well, you can detain a person if he is seen to be acting in a manner hostile to the interests of society. But that preventive detention is a jurisdiction of suspicion. when a person is detained, to allow him access to courts for judicial evaluation of the need. The famous case in England, which the Home Secretary is satisfied. The Home Secretary files an affidavit saying, I am satisfied. Then the court says that's the end of the matter. Liversidge versus Anderson. But Atkins, shattering dissent, said, well, he must say how he is satisfied about. There are objective tests for subjective satisfaction. And that is the test of rule of law. It started in the Habeas Corpus Reforms Act of 1679. The Prime Minister would detain people, send them out of metropolitan towns where habeas corpus jurisdiction would run. And people were detained without accountability. He was the Prime Minister Clarendon. People impeached him. He was banished. He died in exile. And then the Habeas Corpus Reforms Act was passed, authorizing the court to extend the habeas corpus jurisdiction to the Mofussil. And when that was put to vote, it was declared that it was passed by 57 votes to 55 votes. There was, the teller was Lord Porter, Lord Grey. Earl Grey was the teller. Later on, it was found that he had counted one fat lord equal to 10 votes. And then, why did they have to resort to illegal means of supporting a legal issue? Then that was the 17th century episode. In the 18th century, the famous Lord Coke declared, Englishman's home is an Englishman's castle. He said, wind can enter, cold can enter, storm can enter, but king's man can't enter his home. 19th century came in Calcutta, the same thing. You can't exercise this power in the Mofussil. And Amir Khan's case in 1870, they said, we have not derived jurisdiction from the Criminal Procedure Code. We have inherited this jurisdiction from the Chartered High Court. We have inherited the Queen's Bench, the jurisdiction of the Queen's Bench. That was the Amir Khan. Then came in the Madras in the 20th century, 1922. I think it was Govinda Nair. Their lawyers went on strike. And the act was amended as a result of the strike of the lawyers. And I think George Rankin in Calcutta, I think he was then in Calcutta in 1927, Girindranath case. Girindranath case, that's a famous case. Then 21st century, we had Rasool versus Bush, the Guantanamo prisoners. They said Guantanamo is a leased property in the Cuban island. It's not a part of the United States. Your Supreme Court said it won't run there. They quoted Mansfield in the 17th century. He said, you don't have to own the realm of the land, you needn't have to own. If you have control over it, it's sufficient. And see, this is the story of domination of one. This is a kind of a thing which for 500 years we have seen this enacted.
Sir, is it true that you declined district judgeship when it was offered?
Yes, it was not offered in the sense, you see, one of the influential judges thought in 1961 or thereabouts, he said I should accept a district judgeship. In those days, it was not a small thing. Perhaps at the age of, I was about 31 then. Surely it would lead up to the High Court in 10 years from then. But that was, yes, in a private conversation, he said, and I never mentioned it. He told others. I asked him, he declined and all that.
You're someone who's deeply in touch with the culture and spirituality of our nation. You practice yoga not just for its physical benefits, but also its meditative and mental benefits. Have you had any mystic experiences in your life?
You see, sir, I had the good fortune to know some of the greatest yogis of this country. I had the privilege of knowing Sathya Sai Baba. I was Chancellor of his university. And I had known some of the great yogis of our times, because at one point of time I was running after them. I had occasion to see remarkable people. Even today, I shudder to regret that I didn't take full advantage of my closeness to them.
So on one occasion, when the Chief Justice sent a message that he would like to see you, you replied, "I would like very much to see him too. I hope one day we both find the occasion."
Quite right. If you understand the limitations, human limitations, everything will be smooth. If you exaggerate your ego, there's no limit to it. And that's the greatest enemy of peace, internal and outside.
At the time of your elevation as a Supreme Court judge, the erstwhile Law Minister had requested you to come to Delhi and meet the sitting Prime Minister of India, to which you had said, "I apologize, but I'm not in the habit of meeting anyone."
You're right. You see, Mr. Shivshankar called on me when Pathak I had not seen Justice Pathak at all. One fine morning he telephoned to me to say, "I want you to join the courthouse soon, can you come?" I told him, "Sir, I am not the obvious choice. There are seniors to me in my own court." He said, "Leave that to me to decide." After that, the minister, he happened to be a relation of a brother judge of mine who was very close to me, he was also my father's student. He was related to him. We met, I think, in the wedding house of that judge's son. Then he said, "The Prime Minister must also know whom he is appointing. It's the procedure that you should call on the Prime Minister." I told Mr. Shivshankar, "You are yourself a judge. Calling on the Prime Minister is a matter of great honor, and particularly this Prime Minister, young man who has been trying to handle great issues of this country with some aplomb and self-confidence. I'd be delighted to meet him, but on this occasion, if I call on him, it will only mean that I am subtly requesting him to endorse my nomination. I will not do that." He said that's a matter of routine. He even cautioned that I might be putting my appointment at stake. I told him I don't have the impertinence to interfere with the course of providence. If that happens, it will be for the good of the country. Please don't bother yourself about this thing. And he said, "You declined to see him." I said, "Well, you want to put words into my mouth? It will be a very rude thing for me to say I declined to meet the Prime Minister. In this context, I only say it's not proper for me to do that." This information went to Rajiv Gandhi. I had never occasion to meet him at all. But he is supposed to have told the Attorney General, Parasharan. Parasharan telephoned to me the very next day in the night. I had not known him personally. He had appeared before me in some cases in the High Court, perhaps. He said, "Rajiv Gandhi sent for me, Prime Minister, and told me, I am proud to be a Prime Minister of a country. There are still judges like this. Kindly announce his name today before he withdraws his consent." This is how things were happening.
Would you like to talk about your dissent in the Antulai case?
See, Antulai case is bereft of personalities. We are not. The question is the principle of finality. If you say, supposing the Antulai case decided by the majority was later on taken up by another larger bench and said it's not correct. That's why one writer, humorous writer, said about the hierarchy of appeals, transposing it to the medical situation. The surgeon removes the appendix. The appellate medical board says you shouldn't have removed it, you attach it back. The senior surgeon says, no, you remove it. So this is how, it's a principle of finality. First, they said the district judge a high court judge can do the work of the district judge and try the case himself. They said. That was challenged, saying that it is not constitutional to do that, it is not permissible. Another 5 judgments said yes, it is permissible. And after the trial went on, sometime in the middle, it was challenged. I bow to the majority opinion. It is a plausible view. But the issue was that a court of record has power to decide the questions of jurisdiction about itself. It can decide about its own powers. Supreme Court is, of course, a court of record, and it has the power to decide, and it decided. It was specifically raised. 5 judges said we have jurisdiction. And secondly, High Court judge can certainly be a de facto judge in the place where he can be deemed to be a district judge for the purpose of this case. These are subtle things. But they went on a larger philosophical issue of jurisdiction, which was, to my mind, pushed to a little higher extent than it was the tensile strength of the argument bore.
Justice Venkatachaliah, on one occasion during your tenure at the Supreme Court, when a vegetable vendor approached you in court, pleading that his house is being demolished, you instructed certain lawyers to help him file a writ petition.
You see, the question was he had not taken a license. He had put up a building. I was asking the authorities, supposing he demolishes and gives you a plan, exactly the same plan on which the present thing is patterned, would you sanction it or not if it is otherwise eligible? Then why do you want them to go through the motion of demolishing and putting up the same structure merely because he had not taken a technical permission? This is the ways of the world. They wanted it to be demolished, and the same building. I asked him, is this building as he has constructed violative of the bylaws? That's not the question. He has taken it without a license. Supposing he had applied for a license, would have granted a license. That's not the question. He didn't apply. This was the argument.
So it might have been a small question of law in your eyes. For that man, it was his whole life.
Quite right. When somebody says, I apprehend I may not get justice in your hands, the judge can't say, I have looked at myself, I have introspected deeply and very carefully and conscientiously, and I am not biased. That's not the question. You don't look at your mind, you look at the mind of that man and say whether his apprehension is reasonable. It may not be real, whether for him it is reasonable apprehension. That's the test. And this is where vanities and ego of judges must disappear. You must go to the level of the litigant and find out what bothers him. You may answer, give him the relief or not is a different question, but you must ask the right questions.
Speaking about overcoming vanity and ego, on one occasion your car was stopped by a police inspector who unceremoniously hitched a ride in your car, but you did not divulge your identity to him till the completion of the journey.
There are many instances have happened. Someday, some gentleman, some policeman in uniform stopped my car. It didn't have a board or some such thing. He told the driver, and I was sitting, my wife and I were sitting in the rear seat. He told the driver, drive up to that place. The driver looked at me to say whether we should announce whose car it is. I told him, don't do that. At the time when the car stopped at the destination where he stopped, I got down and thanked him and I announced myself. He was shattered. I told him, I said, okay, the car was coming empty. But don't use it as a power authority. As a friend, you can always do it. But he did it as a power authority. He stopped, he didn't even ask question. He said, take me there. See, this happened to Vivian Bose. You must have heard of that story. He was Chief Justice of Madhya Pradesh. He was going to a district for inspection. He was a motoring buff himself. He was driving himself. The head constable was assigned to his security duty, was waiting at the roadside. He stopped the car and said, where are you going? He said, I am going to Jabalpur or Bhopal. He said, drop me. Where should I drop you? At the Thana. So he drove him, dropped him at the Thana and told him he wished him by, and then came to the guest house. By that time, this policeman dressed himself for the security duty for the Chief Justice, came to the guest house. He saw this man, he swooned. Of course, we were both a great gentleman, a great judge, one of the great, among the greatest of the country. He went and patted him on the back, he said, don't bother about it, this is the police, don't worry.
If I may ask your thoughts on the Union Carbide case many years hence.
Union Carbide is a remarkable case of international issues. I don't think any decree that would have, judicial decision that could be made in the case would be enforceable in America. They would not domesticate it in America because they had already planted some seeds of self-destruction in the trial. In the trial, they had planted the seed of proceedings being conducted in Hindi. And such a thing would disqualify the decree for domestic enforcement in the other country. There are similar precedents. Then they filed a contempt petition against Mr. Nariman. Similar in the Bhopal trial court, they filed a contempt petition. So these are all germs of self-destruction of the enforceability of the decree. Here, we didn't do anything. Government had agreed between them. Government wanted 500 million. They were prepared to pay 350 million. And we said the government was prepared to give them 6 months' time. We said, you delete 6 months interest. They will pay immediately now. Add 6 months interest. So we said 470 plus the interest will be 500. This is what you get. This is all that the court did. But one thing we did was, we wanted to keep it in dollar account, which government was reluctant to do. But we persuaded government to do that. And lo and behold, rupee became from 16 to 32 during the period of the deposits. The amount became, in terms of rupees, double.
Would you like to share about your work with the peer committee at the Supreme Court, the peer system that you set up?
I suggested in the Constitutional Review Commission a different pattern altogether. In fact, Nariman said in the course of his arguments in that case, if you accept Venkatachaliah's formulation, I will withdraw the petition. It is necessary to have a Judicial Appointments Committee because this debate is going on and appointments are held up for months and years.
You once famously told Prime Minister Narasimha Rao at the time of your swearing in as Chief Justice of India, when he remarked that during my tenure I would expect the relationship between the executive, the legislature and the judiciary to be cordial, that no sir, that would perhaps be a very sad day for democracy. It should only be correct and I will ensure that it is. How do you feel the relationship between the three pillars has evolved over the years?
It was possible because of the great gentlemanliness of Narasimha Rao. Just the previous day, before the new Chief Justice is sworn in, the outgoing and the incoming Chief Justices are entertained at dinner by the Prime Minister. That's a formal thing. The Prime Minister, very expansively and bona fide, he said, Chief Justice, you will find my relationship with you cordial. I told him, the Chief Justice and the Prime Minister are on cordial terms. It's not been the interest of democracy. I expect our relationship to be proper and I will maintain that propriety on my side. And of course, as a sequel to it, he was a great diplomat. He said, oh, you'll have all the cordiality and propriety. And he said, everybody laughed and he kept it in his mind. And then he called on me a few days later and said, something was festering in your mind when you said that. I told him, you're right. And I told him the reasons why I was a little troubled about the relationship between the Supreme Court and the government. Of course, he set right every one of those things. That's an interesting episode. It was not in serious talk, it was in friendly banter.
In your address to the Karnataka legislature in 2012, you spoke about the need to democratize and reform political parties for the parliamentary democratic system in India.
Yes, if political parties are not democratized, there is no democracy. It starts with the political party. They are the ones who nourish democracy. If they are not democratic, in fact, if a person says, I am going to be the president of the political party for life, is that democracy? And how internal democracy of a political party is a very subtle idea, but a real idea. The subtlety should not obscure the inevitability of the idea. And my personal feeling is this is exactly the reason why we suffer. Jefferson once said, the cure for the illness of democracy is more democracy. And we don't have enough democracy inside political parties. And that reflects itself in the lack of democracy in the polity.
You also spoke about social development and the fact that wealth, health and well-being are not a consequence of economic progress, but rather economic progress follows social preparedness.
This is the great debate between, for example, a school led by, say, two great eminent economists of this country. One is Jagdish Bhagwati, the other is Amartya Sen. Trickling down doctrine is growth at any cost. Ignore everything inconsistent with the idea of growth. This is the Lee Kuan Yew, Lee thesis of the maker of modern Singapore. He said anything inconsistent with growth should be ignored and subdued. And when the growth occurs, it will trickle down and everybody will be happy. That's one school. The other school says no. It is not economic reforms that produce social progress. It is social reforms that generate economic progress. This is the converse of it. And this is exactly, there is one paper which I remember still in 1999, Amartya Sen wrote, India, What Prospects? He said, China and India have two similar advantages. The education level, not literacy, education level of young men and women in the age group of 15 to 18. That determines the progress of the country. And India has an advantage because we have more numbers in that age group of 15 to 18 than China. But see the history last 25 years of comparison. It shows that China's performance, China is 15% of the world's GDP. America is 20% of it. India is 2.7%. And if you see what Amartya Sen wrote about the demographic dividend of India in the form of additional numerical strength in the age group of 15 to 20, and how would we frittered away that dividend?
Sir, you spoke about social development and India's demographic dividend. 422 million Indians are below the age of 18, yet our learning outcomes at the school level are below par. 42% of India's children below the age of 5 are malnourished. What judicial interventions do you think can help India take advantage of its demographic dividend?
I know at the Human Rights Commission we have gone into these kind of traumatic situations. For example, affirmative action commences from the stage of fetal nutrition. 90% of the brain development occurs within 5 years from the child, and it starts when the child is in the mother's womb. Nutrition at that stage to the pregnant mother, that determines the intellectual future of the child. Intellectual future of the child depends on how in the mother's womb its nourishment occurs. And up to the age of 5, 90% of the brain is developed. How much of protein that you give determines its future, intellectual future. These are things which are all known to our people, administrators, because the two things, vastness of the problem, hugeness of the problem. Second is that there is no coherent, concerted, coherent action. The administration has not evolved itself into coherent, concerted action. And third is misleading statistics. You substitute statistics for achievement. These three things are the bane of this country. And what is the solution? It's only experts must find out how we should do that. There's one beautiful instance I remember. An American scientist, they established the correlation between iodine deficiency and thyroid malfunction. How to supply was the question. You can have iodine pills and put in bottles. Which villager will go to a place and take it, open the bottle, take one pill at every time? Nobody does it. There's one scientist, Dr. Ramalinga Swami. He thought of the idea of iodizing salt. And say, for example, on average, you take 8 to 10 grams of salt every day in your food. You load it appropriately. He did that. That revolutionized the whole thing. In the thyroid region, the growth, the change was demonstrable.
Speaking of Lee Kuan Yew, a gentleman and a scholar not unlike yourself, he wrote in his last book, One Man's View of the World, to keep one's light under a bushel. And that is perhaps truest for you. Your knowledge is only matched by your humility. And I think the three qualities of a judge that you exhibit, that of a historian, that of a philosopher, and that of a prophet, are evidence to that.
Thank you very much. I'll tell you, all these kind of intellectual virtues, as you may say, not equivalent to one beautiful sentiment that your father expressed. See what in action, what he did and what he thinks. Maverick it may look, but these are the people who make the difference, Baba. All these theories work as guideposts, handposts on the direction, but the walking one must do. And this is what I find in a short interview. There's no touching. A man who thinks that propagating the culture of pickles is as important as culture in neurosurgery.
Generations of lawyers look up to you. What is your message for the nation's youth?
I am not so big as to give any message, but I can only share one feeling. You see, the humbler you behave, the rewards of life are richer. Many things you learn which you can't learn if you are arrogant. At least it will make life easier for one. You can't make a contest of everything. And a lot of things could be done with the present technology. Great dangers are ahead, the misuse of technology. The judicial system can greatly benefit from the revolution that's going on in science and technology.
Sir, you've always been a big votary of the use of technology in judiciary, particularly artificial intelligence and machine learning.
Artificial intelligence won't solve these problems. It will only generate algorithms. It will give you data, it will churn in the supercomputers and tell you the interpretation of data, the learning you can make out. For example, the medical data can tell you by 2030 how many diabetics will be in this country, how much of parchments are necessary, how many renal dialysis machines are necessary, how much of insulin is necessary. All this it can tell you. But it can't decide an individual case. It can give you generalities on which a formula it will give you. You can assume that so many diabetics will be in 2030. And supposing somebody says some revolutionary medical development occurs and diabetes is eliminated, say the supercomputer puts that also into the scales and makes a prediction. And this is predicting on the basis of data available. You can't decide one individual question. For example, for sentencing, you can. Well, in such age group, the background, social background, the nature of the crime, and what is the average punishment. That is data in regard to punishment, precedents in regard to punishment. That's not artificial intelligence. Artificial intelligence will give you algorithms on which you can generalize make predictions.
Sir, how did you manage to bring down the pendency of cases without the use of technology?
See, it is not the work of one judge. Two remarkable contribution in this direction was the work of Justice Ahmadi. See, all this happened because of an observation made by Palkhiwala in 1991 that the Supreme Court would take 300 years to cleanse this mess. And the Economist of London wrote a scathing indictment of the Indian judiciary on the basis of that. And that's how the matter had to be taken up. In fact, the very first thing I did was to appoint the Ahmedabad Institute of Management to study the case law management and advisors. When I went to the Human Rights Commission, the first thing I did was to engage McKinsey, Rajat Gupta, to survey and how other international institutions are working, similar institutions, and how we should upgrade our methods. So, learning from the experience of others.
Sir, your work in human rights is well known. What was at the forefront of your mind during the Sheetal Barse case?
She was a very active worker. She had a lot of experience in handling the problems of children. But there are high-strung people. There are people with determined kind of things. And they found that the courts were not moving at the same pace they wanted the courts to work. This is always the tight relationship between courts and activists. courts can't keep pace with them, nor be dictated by them. That's the problem.
What would your advice be to the current sitting Chief Justice of India?
I am nobody to advise him. My very earnest, very respectful request to him is just give a serious thought to reforming the system. Cases are pending for 15 years where it should not be pending for more than 15 months. There are cases which are pending for years together, routine matters and matrimonial matters, child custody matters. This could all be streamlined if you take one strong look at it and say which part of our procedure is judicial, which is purely administrative and managerial in nature, and those aspects are entrusted to systems experts, systems men. Procedural matters, managerial procedural issues, which can be handled to systems experts, and the pure judicial side could be handled by the judges themselves.
Justice Venkatachaliah, today, as you look back at 93 years of your service to the nation, how do you feel, sir?
Thank you for this very searching question. I am personally grateful to God for the long innings that He gave me. But when I reflect upon the predicament of our society and fellow men, it looks as if we collectively, as a nation and as a people, could have done much better. But at the same time, I've seen so much of graciousness, so much of kindness, so much of consideration amongst human beings, particularly amongst those who don't have the blessings of great wealth. Ordinary day-to-day living has tossed up such extraordinary instances of kindness and service to fellow men. And this is a very rewarding experience. I think the culmination of this ideal is possible only in this country more than anywhere else in the world.
It's been an honor and a privilege to spend this morning with you. Thank you so very much for taking the time out. Jai Hind.
Thank you very much. Please tell your father there's so much we can do to compensate for the dehumanizing side of technology by our culture and heritage and values of this thing. Matthew Arnold's book, Culture and Anarchy, even today rings a beautiful sound. With the expansion of this communication system, it is simply possible. Some of the most beautiful things, sentiments which will add savor to life itself, they stop this process of dehumanization. Dehumanizing is not demonizing. Eliminating human element in the management of things. That will make it dry and sear and barren of emotions. This is where country runs into, young men become cynical about moral values. Thank you.